In order to bring a lawsuit against a medical device manufacturer or a pharmaceutical company, the injuries have to be serious. It would not make sense for a client to bring a relatively small injury to trial, because the trial of a medical device or pharmaceutical in cash probably costs about $10 million and would take tens of thousands of attorney hours to bring it there, plus the paralegals and all the support staff. So it wouldn't be justified to bring something that was a small case involving a medical device or a pharmaceutical. But everybody's case is different. Is the person who's suffering from vision damage allegedly caused by Elmiron, are they 20 years old or 90 years old? Are they retired or still working? How much are they making if they're working? Are they making $20,000 a year or $100,000 a year? Is sharp vision important in your line of work? Some occupations, you really don't need to have that sharper vision. I mean, it would be nice and you'd want it, but it's not really affecting. For example, if you were a pilot, you couldn't be a pilot if you have Elmiron-related retinal toxicity. If you were a surgeon, you probably couldn't be a surgeon if you had Elmiron-related retinal toxicity. So everybody's damages are different. But I think we all can agree that you have damage to your retina that affects your eyesight so that you can't read, that you can't perform your daily functions, you can't watch TV. That's a serious injury and needs to be compensated accordingly. And that's what we fight for. Well, there's no guarantees about settlement, but we try to litigate our cases efficiently. Once we get involved, we try to move it as effectively as we can. It really depends upon the judge. Some judges have dockets that have a lot of cases, and they really have limited time for any particular case. Some judges' dockets are lighter than others. So it just depends upon the judge and how much time the judge could afford to the particular case. But we try to move them very quickly. Parker Waichman, as most other personal injury law firms, taking cases such as this, and in Elmiron in particular, do so under what we call a contingency fee agreement, where the law firm, Parker Waichman, will advance all the expenses of litigation. You will not have to lay out any money for the litigation. We will lay out all the funds required to bring your case to trial. This can be very expensive. Doing discovery costs millions and millions of dollars. We're going to get, I would imagine, tens of millions of pages of documents and data from the defendants. Some defendants like to give us even more information than we're entitled to or that we need, because they flood us with documents. So you go try to find the needle in a haystack. But what we do is we hire experts who have electronic tools, who can mine the information that we get and ferret out those bad documents. Bad meaning bad for the defendants. Because at the end of the day, the one thing that I've learned from doing this for almost 40 years is bad documents drive damages. And when you could show the defendants committed bad acts, really bad acts, bad conduct, hid things they should have disclosed, That drives the amount your clients are going to get. That drives the amount our clients are going to get. And that's why it's so important that we do the work so we have firsthand knowledge of these bad documents so that it benefits our clients. It could cost us tens of millions of dollars, like I said, to bring these lawsuits on. But the advantage is that some clients will have, and I think almost every client, the advantage, like I said, it's going to cost a lot of money to bring this litigation to its conclusion, to a successful conclusion, successful for our clients. And in order to do that, we're going to be spending a lot of money. We have our document examiners. Those experts cost millions of dollars, and they get paid up front. We're going to have the best experts in the world, and they're very expensive. But that's what they cost. It's going to cost a lot for all the attorneys and paralegals that are dedicated to this case, and this case only. But the good thing is, and the thing that benefits our clients, is that Parker Waichman represents a lot of clients that are claiming that Elmiron has destroyed their retina. And a lot of the expenses that we've spoken about already will benefit all the clients. So if there is a resolution to this case, we could amortize or spread those expenses out over all of our clients so that the amount charged to a particular client is relatively small. If we only had 1 or 2 cases, or 5 or 10 or 20 cases, the burden to every client would be extreme. But because we represent a lot of clients in this litigation, they're going to benefit by having us allocate or amortize the expenses in an equitable way. Everybody's not going to get charged the same amount. It's going to be equitably done with court supervision or court-appointed special masters or with settlement administrators, and it'll be equitably done for all of our clients. So it'll be equitably done, spread throughout all of our clients. Now, some of the expenses are client related. For example, if we get medical records in your case from your doctors, those are your expenses. Those do not get spread to other clients. If we get a report from your doctor and we have to pay your doctor for that report, that is your expense. If we meet with your doctor and we have to pay your doctor for that meeting, that is not spread, that is your expense. But at the end of the day, based upon my almost 40 years of experience doing this, the way we handle it is most effective for all of our clients. And like I said, since we have a lot of clients, the more clients we have, the less it is for everybody. So I think the way we've worked it is most advantageous. Well, it's always a possibility that you'll have to go to court. The possibility that you might have to give depositions. What happens in cases like this, most of the time, is that the court will select a number of cases that will act as what they call bellwethers, samples. And that maybe the plaintiffs will pick a few, defendants will pick a few, and they'll go to trial. But there might be 10,000 or 20,000 cases filed, and they're going to pick 4, 6, 8. It's up to the judge. But it's a low number comparative to the number of cases filed. Some litigations, there are hundreds of thousands of cases filed, and they're only going to pick 6 or 12. So the chances of you going to court are slim. The chances of you going to depositions are slim. You might have to have a physical examination of your eye all that is very slim unless your case is picked as a bellwether. Well, hopefully you have medical coverage, health insurance coverage from your employer or the employer of your spouse. Medicare or Medicaid also affords medical coverage, so hopefully you have some way of getting your health care bills covered and the cost of the imaging that you need in order to make the diagnosis of Elmiron-related retinal toxicity.